Well, good evening and welcome. I'm very pleased to see so many of you here this evening, not only in the room but also online. This is the second of our readers' lectures for the season, and I am delighted to be able to introduce my old and dear friend, Professor Kristin van Zwieten, who rejoices in the title of the Clifford Chance Professor of Law and Finance and Gullifer Fellow at Harris Manchester College and the University of Oxford. And is an absolute expert in insolvency law and indeed most other aspects of the law. We've been discussing it.
About that. I think we should better stop now with this introduction.
We've just been discussing injury for nervous shock and things like that in talk, which has never struck me as one of those things, but Oxford academics tend to be polymaths, so we're in for a very interesting evening. Kristin, over to you.
Thank you very much, Richard. So should I turn this now to green?
Yes, please.
Right? Yep. Let me get my phone to keep an eye on the time. So what should I do to... I'm pressing my magic button. I could do it on the control panel if you prefer. Is that easier? No, it's not going there either. Which is strange since we tested it just before. Thank you. Thank you. Well, thank you very much to Master Salter in Oxford, Professor Salter, for the invitation to give this lecture. And thank you to all of you for coming along in person and online. Crisis talk, and I think especially COVID crisis talk, is kind of a hard sell in 2024. I think many of us feel somehow reluctant to turn our minds back a mere 4 years. The experiences of 2020, I think, have somehow been partitioned off in our minds as if they were the experiences of someone else's life rather than part of our own. So in reporting to you today on some of the results of a project that I've been leading in Oxford on one aspect of the policy response to the crisis, that is the response by governments to an anticipated wave of business bankruptcies associated with the imposition of periods of trading shutdown or lockdown, I hope to be able to make clear the need for researchers working at the intersection of law and finance to continue to train their scholarly lens, as it were, to continue to look back on the early pandemic period. Institutional responses to a crisis, even when they're presented as purely temporary interventions, can have long-run effects. We must all live with the decision of governments to extend massive bailouts to firms in the real economy with a view to preventing mass defaults. The resultant increase in national debt burdens, as Thomas Piketty argued early in the crisis, will affect us all one way or another. Other long-run effects of bailout programs may be more subtle, but nevertheless significant. Programs that appear to be linked to cronyism and or vulnerable to fraud, both suggestions made in relation to the UK policy response, can reduce public trust in the state. More generally, I think any promise by national governments to insulate firms from the effects of a crisis. In France, Macron memorably pledged no business, whatever its size, will face the risk of bankruptcy in March 2020. I think any promise of this kind can be predicted to have at least some effect on investment incentives after the crisis. Of course, a decision not to intervene might also have altered investment incentives in the long run. And there are several groups of scholars writing about this who describe this kind of long-run effect as a belief scarring effect, the effect of parties awakening to the possibility of future pandemics with associated default and bankruptcy risk. So by beginning here to sketch some possible long-run effects, I don't mean, of course, to suggest then that states should not have intervened. And I'll return to why in a minute I think states were right to intervene. Instead, here I merely mean to give some sense of what might be at stake in the design of the policy response to such a crisis. Now, importantly, since one part of the response to such a crisis might be to adjust the legal framework, to change some aspect of the rules that would otherwise regulate the position of a debtor that has become unable to meet its fixed obligations as and when they fall due. The legal system may itself be changed in the long run by the crisis. Temporary amendments made in response to a crisis can build momentum for permanent change. And as I understand it, the history of crisis-induced amendments to the German rules on the personal liability of directors in insolvency is such an example of temporary amendments that eventually built the case for permanent change to those rules. More ambitiously, governments may attempt to make permanent changes to the rules from within the context of the crisis, seeing an opportunity to make changes that is absent in good times. A quick historical survey reveals many cases of permanent insolvency reforms that are made in the context of or in the immediate aftermath of a crisis. And I've given you on the screen just two very interesting books charting the history of such reforms, one in economies after the collapse of the Soviet Union, and the other in economies affected by the East Asian financial crisis. In today's lecture, I want to suggest that the UK experience of making permanent insolvency reforms during the pandemic reveals some of the dangers that are inherent in seizing the opportunity for reform that a crisis presents. And since insolvency and restructuring laws affect investment incentives ex ante, and since such laws regulate hard distributional questions that have higher political salience, getting the reforms right matters. Again, I think it's right to say that the stakes are high. So, with this context in mind, let me begin. In The Instrumental Justice of Private Law, Alan Calnan characterises rights as tools created out of necessity to assist people in doing things they can't do unaided, and observes in relation to the limits of such rights, for every tool, there is some job it cannot do. The resistance of the material to which it is applied is simply greater than it can withstand, and it finally fails from the pressure. Now, in corporate insolvency scholarship, the supply of insolvency and restructuring procedures by the state is conventionally explained in the same way, as a supply of tools by the state for the treatment of a particular problem, achieving a coordinated treatment of the debtor's expected inability to meet all its fixed obligations in full in the interests of its fixed claim holders, a particular problem that parties can't solve unaided, or which can be solved by the state in ways that are superior to the solutions that would attain if the problem were left to be treated by private ordering alone. And in the past 20 years, huge resource has been invested in introducing and or refining such procedures by governments around the globe. But on the onset of the COVID-19 crisis, governments seemed to very quickly and unanimously form the view that these procedures were not the right tool, as it were, for the treatment of COVID-19 related financial distress. To use Calnan's framing, it seemed the view was that this was a job that the existing legal framework could not do. Rather than leave a business debtor's inability to meet fixed obligations during periods of lockdown to be treated by the pre-pandemic law, states moved very rapidly to offer extraordinary packages of relief that were designed to prevent, or at least to postpone, mass defaults. Were states right to intervene? Were they right to be wary of leaving affected businesses to be treated? Were they right to be wary of leaving affected businesses to be treated by the application of the pre-pandemic legal framework? In the first part of my lecture today, The Crisis as a Threat, I will suggest, drawing on an early paper by me and two of my academic collaborators on this project, Horst Eidenmuller and Oren Sussman, that there was a good case for states to intervene, but that there was no easy path to take in doing so. The most tempting path politically would be to administer bailouts, that is, for the state to assume some or all of a debtor's fixed obligations. But that would simply postpone the allocation of the costs of this relief policy to some future period, and probably to future, younger taxpayers. The alternative, requiring creditors and counterparties to forgive some or all of a debtor's fixed obligations during a trading shutdown period, Now that would require the hard choice to be made up front, but it would only, for reasons I'll explain, be superior to treatment by the pre-pandemic law if the state could somehow ensure that the costs of this relief really would be allocated to those best positioned to bear it. And that might be quite hard to do in practice. Now, in the jurisdictions that we've examined in the project that Richard invited me to talk about today, states did not write policies in the end to fully relieve debtors of fixed obligations during periods of trading shutdown. The state did assume some classes of obligation through cash bailouts, but they simply deferred others, either through ensuring the availability of new loans or by requiring creditors and counterparties to wait for longer to be paid. And that meant that at least some liabilities were simply left on debtors' balance sheets to be dealt with later. At the same time, states also saw an opportunity to update their restructuring laws so that they would be optimised for use, so the thinking went, by debtors in the need of a debt restructuring after the crisis subsided. In the second part of the lecture, the crisis as an opportunity, I want to use the UK as a case study for exploring some of the risks associated with using a crisis as an opportunity to reform a state's corporate restructuring toolkit. Now, before turning to the first part, I should perhaps say something brief about the language of legal tools and legal toolkits. By using this language, I don't mean, of course, to suggest that I have subscribed to some purely instrumentalist view of law and legal institutions, at least if legal instrumentalism is understood to reduce the analysis of legal rules to their ends and somehow to invite judges to apply those rules in ways which are sensitive to the expected end result at any particular time with a view to meeting current social needs. So that, for example, treatment under a rule in good times might look different to treatment under the same rule by the same courts in different, worse times. As Lord Burroughs noted in his speech in the recent decision in Paul, that's the decision that Master Salter anticipated in his introductory remarks, courts are generally, I think, very poorly positioned to assess socioeconomic policy arguments, but even if they were well positioned to do so, such economic policy considerations would need somehow to be reconciled with existing legal principles, because it is on these that the cogency of the system depends. And this process of reconciling the apparent change in the economic climate that warrants a difference of approach with existing legal principle would inevitably change the law. All decisions of courts do so through the channel of the doctrine of precedent, for better or for worse. And I note parenthetically, therefore, that I see real difficulties with the suggestion in this recent book, Law and Macroeconomics, that judges should somehow exercise existing discretion in the insolvency context differently, depending on whether or not they are called to exercise that discretion in a recession or outside a recessionary context with the goal of stimulating aggregate demand in the economy. That is a suggestion with which I have great difficulty. In this lecture, I've used the language of legal tools and legal toolkits because that's the language that was used by policymakers here and elsewhere around the globe in describing the policy response to COVID-19 distress, and because I think it captures very well what seems to have been in the mind of policymakers. Policymakers thought of themselves, I think, as somehow seated at a giant control panel at the beginning of the onset of the pandemic. And the idea, I think the thinking was that they would somehow switch off one piece of legal equipment, the pre-pandemic insolvency framework, supply sui generis tools in its place, write extraordinary relief policies, and then during the period of legal dormancy, while the equipment is switched off, try to upgrade it, right, to do a system upgrade. For the remainder of the talk, I hope to be able to draw out some of the lessons that we can learn from careful, close analysis of these experiments. So first, the crisis as a threat. Prolonged periods of trading shutdown where businesses in certain sectors cannot trade can be predicted, can be expected to produce a cohort of newly distressed businesses. Once cash reserves are exhausted, businesses will begin to default on their fixed obligations, and crucially, This effect will not be confined to businesses with debt, to leveraged businesses. Any fixed obligation, an obligation to pay license fees to a licensor, rent to a landlord, wages to an employee, any fixed obligation will do. Consistently with this, there's a nice recent working paper from Serato and others that's cited on the slide, which documents how solvent firms in Europe drew down all available credit lines to shore up their cash position on the onset of the first wave of the pandemic. Now, most jurisdictions provide more than one procedure for the treatment of a debtor that's become unable to pay its fixed obligations as and when they fall due. But government seemed clear that it would be undesirable to leave businesses in sectors that were adversely affected by lockdowns to be treated by this framework. Instead, they intervened to prop up firms with a view to preventing mass defaults and associated insolvency filings. Was there a good case for intervening? Well, in a paper written early in the pandemic, my project collaborators and I, as Horst Eidenmuller and Oren Sussman, both at the University of Oxford, we argued that there was a good case for governments to intervene in response to the predictable risk of default associated with declining revenues during periods of trading shutdown or lockdown. The lost revenue itself was irrecoverable. No policy response can bring back that revenue. But the case for intervening lay in the potential to minimize the amplification of that shock through the infliction of financial distress on a cohort of previously solvent debtors. Let me explain a little bit what I mean by this amplification effect. The infliction of costs over and above what Oren Sussman termed the unavoidable minimum. In a do-nothing scenario, businesses would be pushed into default and from there into enforcement processes by creditors. Such processes and the threat or the anticipation of such processes might lead to assets that are worth more together being broken up and sold piecemeal. That's an additional avoidable loss over and above the initial unavoidable minimum. Now, the applicable law might provide, as English law does, some mechanism for ensuring a sale can be achieved on a going concern basis rather than a piecemeal basis. But within a crisis context, such sales might only be achievable on what economists call a fire sale basis. Fire sales might lead to assets being deployed less productively by buyers than they would have been by the seller. That's an empirical question on which I think it's right to say there's some scholarly debate. But even if fire sales didn't produce this result, mass sales at less than fundamental value might have systemic implications. They might depress asset values more generally, and they would certainly be expected to increase the losses that have to be registered on the balance sheet of banks and other financial intermediaries, with a lot of knock-on or associated effects. Now, the applicable law might, again, as English law does, provide one or more procedures for restructuring a debtor's liabilities, where this is better for creditors than an immediate forced sale. But such procedures tend to be very costly to use, and they seem to us to be a poor fit for the treatment of the particular features of COVID-19 distress. Restructuring procedures tend to focus on reducing a debtor's debt burden and assume the debtor can meet its fixed costs during the period of a restructuring negotiation. But in this crisis, as I've already sought to emphasize, businesses wouldn't need to have any debt at all to have become distressed, and the source of the problem was fixed costs. Changing restructuring laws to better fit the peculiar features of COVID-19 distress, now that seemed to us to be a very bad idea, since it risked distorting those laws for the longer term, for future post-crisis periods. And in any case, forcing stakeholders en masse into a bargain with a view to sharing the burden of COVID-19 related losses, as well as the cost of the bargain process itself, that would reintroduce the systemic concerns that I've already alluded to. And in an important paper on this theme, which I've cited on the screen, a paper by Elenov and others, these authors chart how the infliction of losses on lenders through forced defaults and associated treatment could increase the cost of capital, leading to declining investment by firms and requiring states in the end to bail out newly distressed banks. Again, the costs of what the authors term a doom loop, in their words, mutually reinforcing spirals of firm distress, financial sector distress, and government bailouts. Again, these costs are additional to the initial unavoidable minimum, the lost revenue that we can't get back. And the authors model how firm bailouts can be used to short-circuit this doom loop. Bailouts enable the state to treat the problem, the continuance of fixed obligations during a period of trading shutdown, at its source. In theory, a state could write a bailout policy under which all of a debtor's obligations, rent, license fees, interest on financial claims, wages, are assumed by the state for the period of a trading shutdown. That kind of bailout policy would enable a debtor to exit from the period of shutdown in exactly the same financial condition as on entry. The alternative route to achieving the same result for the debtor would be to order that landlords, licensors, and financial creditors have to forgive claims for the duration of the shutdown. But such a bail-in alternative would only be effective in achieving the overall policy goal of minimising the amplification of the shock if it could somehow be passed through the economy all the way to ultimate savers, to the current savers in the economy, so that, for example, landlords have to forgive rent but have their obligations to pay interest on financial claims forgiven during the same period. If you can't pass through the bail-in mechanism all the way to current savers, then you're going to end up with a bunch of distressed intermediaries, and we're back to the doom loop that I've already discussed. Potential challenges or difficulties with writing such a bail-in alternative include whether, as a matter of domestic law, it would be lawful to write such a rule, and at the cross-border level, whether such a rule would be recognised as effective by foreign courts, including in relation to foreign-denominated currency. But in our view, the idea nevertheless merited further exploration in theory because of the obvious advantages of allocating the costs of the state's relief policy up front to current savers when compared with deferring, as a bailout does, all the hard choices to later on, when there's no guarantee that the way that governments will in the end make those hard choices will be in such a way as to ensure that the costs of these relief policies are really allocated to those who are best positioned to bear them. So much for the theory. What did states actually do in practice? Well, first, they moved to quickly suspend any duties under the applicable law to file for insolvency proceedings, and they restricted creditors' ability to initiate such proceedings. This is a lovely slide from Eurostat, and the red line is declarations of bankruptcies, and the sharp drop is the first quarter and a bit of 2020. Next, states moved to treat the problem at its source by developing relief packages that were designed to prevent mass defaults. Bailouts appear to have been the dominant strategy for treating the fixed obligations of debtors in the real economy, but most states also experimented, at least to some extent, with extraordinary moratoria for at least some classes of obligation. You have a nice depiction of this on the slide from a paper from AR et al. And others at the IMF, and that shows you which European states experimented with such extraordinary moratoria. Most did, and the bulk of these experiments were made available not only to household but also to business debtors. Extraordinary moratoria are a species of bail-in. They require the rights holder to swallow a postponement in the satisfaction of the debtor's obligation. In economic terms, they mandate an extension of maturity in the claim, but they don't require the underlying obligation to be forgiven. That stays there on the debtor's balance sheet, as it were. In relation to bailouts, there was significant variation in the scope and other aspects of the design of these bailout policies across countries. And there's a very nice paper by Ebeke and others that classifies and computes the intensity of a range of relief policies across Europe. In our own project at Oxford, we have developed a hand-collected data set in which we code the policy response in a smaller sample of largely European jurisdictions. And in that project, we find, this is work in progress with me and my co-authors, that some bailout policies may have gone further than necessary to relieve a debtor of its fixed obligations, so offered more relief than is necessary to enable the debtor to avoid defaulting on fixed obligations. But we acknowledge, of course, and we did so from the beginning of this project, that there is a fundamental trade-off in play for governments. The more carefully you calibrate your relief policy so that it goes no further than is strictly necessary to minimise the amplification of the shock, the longer it takes to roll out the relief policy. And taking a long time to roll out the relief policy might undo the overall policy objective of minimising the amplification of the shock. Now, although there was plenty of variation in the way in which COVID-19 bailout packages were designed, it is possible to discern a basic pattern across countries. All of these packages involved some combination of wage liability assumption by the state, in this jurisdiction the furlough scheme, other cash grants, tax deferrals, and state-guaranteed new loans. New loans, guaranteed or at least partly guaranteed by the state, were a major plank of COVID-19 relief packages across Europe. In the quote on the screen, this is described as a feature of relief packages in 39 of the 44 jurisdictions that are surveyed in AR and others' paper. In the UK, new loans guaranteed by the state were a very significant component of the government's early policy response to COVID-19 related business distress. You might recall Prime Minister Rishi Sunak saying this on the 17th of March 2020, announcing an unprecedented package of government-backed and guaranteed loans equivalent to 15% of GDP. If demand is greater than the initial $330 billion the government promised, said the Prime Minister, I will go further and provide us with as much capacity as is required. I said, whatever it takes, and I meant it. Although the state went on to assume many wage obligations through the furlough scheme and to restrict the enforcement of rental arrears by landlords, the government's strategy for other types of fixed costs appears simply to have been to enable companies to access new finance, or in other words, to swap out short-term obligations owed to creditors and counterparties with a longer-term obligation owed to the bank, backed by the state. Again, notice the effect of this strategy is that the debtor is not relieved of the underlying obligation. It stays on the balance sheet. Overall, the combination of bailouts by way of loan rather than cash and bail-ins by way of extraordinary moratoria, maturity extensions rather than write-downs, means that debtors would not have been expected to exit from a period of trading shutdown in the same financial condition as on entry, and instead would exit with more liabilities on the balance sheet. In this sense, I think it's right to say that the need for later restructuring was somehow baked in to most COVID-19 relief packages around the globe. In this respect, the crisis might have functioned not only as a threat to the existing legal framework or to the utility of that framework, but as an opportunity to refine that framework, and in particular, as an opportunity to implement long sought after changes to corporate restructuring laws. This is the second part of my talk, the crisis as an opportunity. In general, it seems to me that insolvency laws are pretty sticky, that is, hard to change. I'm exploring this idea in some forthcoming work, but it's also a claim made by some other insolvency law scholars, and I've cited on the slide a super interesting paper by De Ruscha on the history of insolvency law reform processes in Belgium. To the extent that stickiness, this hard-to-change quality, is a function of political will, with there being little appetite for making reforms in good times, we can see periods of economic crisis as perhaps periods in which space will open up to drive through reform, to drive through legal change, especially if you're a well-prepared policymaker who has the dream legislation sitting in the drawer, as it were, awaiting the onset of a crisis, awaiting an opportunity. And there is a lovely quote from Baroness Neville Rolfe on the screen reflecting on how the Food Safety Act was enacted And she reports, in very similar terms to what I've just been setting out, that the legislation had been sitting in what she terms the famous Whitehall drawer for nearly 10 years. But it was only when the suggestion was made that there was a salmonella crisis in British eggs that there was suddenly appetite for reform, and the legislation was over the line, pulled out from the drawer, immediately enacted. Of course, driving insolvency law reforms over the line during a period of crisis is also obviously risky. Making full use of the opportunity to make changes to the legal framework implies that you're going to make permanent, not merely temporary changes to the legal framework. But it might be hard to ensure, or hard to avoid, design features of the legislation somehow being distorted by the particular features of the crisis. Normal safeguards against legislative missteps, such as impact assessments, other forms of consultation, are typically disapplied or at least diluted in an emergency context. And of course, crisis rulemaking processes will not necessarily be immune to capture by interest groups. Indeed, it might be that those who were already well positioned to influence or capture law-making processes outside of a crisis are particularly well positioned to do so in the crisis, especially where it affects them. And that's basically the upshot of the very interesting paper from Jung and others that I've cited on the screen. For my remaining 12 minutes, I want to offer up the story of permanent law reform in the UK in the first few months of the pandemic as an illustration of the risks of in-crisis insolvency reform. And the legislation that I'm going to be speaking about is the Corporate Insolvency and Governance Act of 2020, or CIGA, which was rushed through using the fast-track legislative process in the early months of the pandemic. This legislation, as the government explained it at the time, was at once a crisis measure, justifying the use of the fast-track legislative process, and not a crisis measure, for it would implement a plan that the government had been developing between 2009 and 2018, on which it had consulted widely and which it believed would be of benefit to businesses generally, not only within but beyond the crisis. And all this justified the making of permanent rather than merely temporary changes to the law. At first glance, then, this legislative instrument appears to be a great illustration of the case of the well-prepared policymaker who pulls the reforming legislation out from the drawer when the crisis generates an opportunity for enactment. In a recent paper, I argue that the government failed in its attempt to have it both ways, as it were, and instead produced permanent law that bears the marks of the crisis in which it was made and suffers from this. Let me briefly explain why I said this by outlining the government's pre-pandemic plan and then the obvious ways in which the end result departed from this plan. And then I will conclude. So first, what was the pre-pandemic plan? After several rounds of consultation on restructuring law reform following or in the aftermath of the global financial crisis, the government settled in 2018 on a program of restructuring law reform that would make three key changes to the law of this jurisdiction. First, the government would introduce a new freestanding moratorium on enforcement action by creditors. This moratorium procedure would be modelled on the moratorium already available in Schedule B1 of the Insolvency Act to debtors that enter administration, but it wouldn't require directors to hand over control rights to an insolvency practitioner. So directors would retain control rights but have the benefit of an administration-like moratorium for a short period with a view to facilitating early restructuring in cases in which the creditor body was large and heterogeneous, where it's hard to coordinate a consensual solution. That's the first plank of the reform agenda. Secondly, the government would introduce a new constraint on the ability of suppliers of goods and services to terminate a contract for supply or do any other thing by reason of the counterparty's entry into insolvency proceedings or by reason of a change in the debtor's financial condition. The idea of this reform was to help to ensure continuity of supply during restructuring negotiations and reduce the need for insolvency practitioners to make ransom payments to suppliers with who could credibly threaten to terminate if ransom payments were not made. That's the second plank of the reform agenda. Finally, there would be a new procedure, the restructuring plan, that would be introduced to complement the existing scheme of arrangement procedure in Part 26 of the Companies Act. And this procedure would be introduced with a view to enabling a dissenting class to be bound to the terms of a compromise or arrangement where the statutory conditions were satisfied. Schemes of arrangement offered only the ability to bind dissenting members within a class. This procedure would enable you to bind dissenting classes, but that would be subject to safeguards, including, the government suggested in 2018, a flexible absolute priority rule that would require value to be distributed to senior creditors under the terms of the compromise or arrangement ahead of junior ones. So that's the plan. What did we get in SEGA? Well, a quick glance at SEGA suggests the government did exactly what it said it would do. We now have a new freestanding moratorium, that's Part A1 of the Insolvency Act. We now have a new constraint on the exercise of rights to terminate contracts for the supply of goods and services, that's Section 233B of the Insolvency Act. And we now have a new restructuring plan procedure that sits alongside the scheme of arrangement and is contained in Part 26A of the Companies Act. Yet closer inspection at these parts of the statutory framework reveals material departures from the implementation of the pre-pandemic plan. So what were these departures? Let me just give you some taste of these. This is not exhaustive. First, in relation to the moratorium, concerns about the financial stability effects of introducing a freestanding moratorium against the backdrop of an economic crisis led to some, if I may say, mighty peculiar drafting choices in Part A1, and in particular to the almost wholesale insulation of financial creditors from most of the effects of the freestanding moratorium. The result, in my view, is quite a bizarre procedure, actually, which largely insulates financial creditors while staying operational creditors, so anyone other than the suppliers of credit. And in this respect, it is contrary to the intention of the pre-pandemic planners, not at all equivalent to the moratorium in administration. And it is also not, for the same reason, at all, in my view, a device that can be used to facilitate a debt restructuring, an early debt restructuring among financial creditors. In the case of the freestanding moratorium, I'm afraid that the enactment of this proposal within the crisis context has meant that the policy objective was simply not met. In relation to rights of termination in contracts for supply, the government here went further than originally envisaged, restraining not only a right to terminate a contract for supply by reason of the commencement of insolvency proceedings or by reason of some change in the debtor's financial condition. The end result in Section 233B also restrains any other right of termination, whether or not linked at all to the debtor's financial condition, provided it's not been exercised on the commencement, or not yet been exercised on the commencement of a relevant procedure. In my view, this result is actually pretty hard to justify in theory. I find it hard to understand why the section was drafted in this way. Moreover, Section 233B, presumably because it was drafted in such haste, does not contain the kinds of protections for suppliers that one would expect to normally accompany the introduction of a new restraint on rights to terminate. In short, in my view, while Section 233B does arguably deliver on the original policy objective, it does so, in my view, at unnecessary cost. Finally, the restructuring plan procedure in Part 26A. This looks largely like the government planned it to look when it spoke about this in 2018, with one very striking exception, and that is the absence of a priority rule provided by statute to regulate the exercise of the power to sanction a plan in the presence of a dissenting class. Members of the dissenting class must not be worse off than in the relevant alternative. That's a precondition to having jurisdiction to sanction. That goes to jurisdiction. But the distribution of value over and above what you can expect in the relevant alternative, and the question of whether or not it's permissible for some junior class to be made relatively better off than a senior class, those questions have been left for courts to determine through the development of the principles that govern the exercise of discretion to sanction in the presence of a dissenting class. And in the recent paper, I argued that whilst courts were certainly capable of doing this work, they were capable of filling out the statutory code by supplying the principles that would govern the exercise of discretion. In my view, it was undesirable to ask courts to develop such a distributional rule. This, in my view, was work that should have been done by Parliament. And I think recent case law, including the decision of the Court of Appeal in Adler, both confirms the capacity of courts to do this work and the serious difficulties in asking them to do so. 4 years on, I think it's right to say that serious questions remain about what we mean when we now ask whether or not the plan is a fair one. Again, it seems to me that this is a case in which the policymaker's objective has been achieved at unnecessary cost. So let me conclude. Responses to economic crises have long-run effects. Getting it right matters, as does learning from when it has gone wrong. Identifying where things went wrong or could have been better is important, not because we think we could have done better ourselves had we been sitting at the control panel during the emergency, but because looking backwards can help to assist those who will be sitting at the control panel next time around in some future crisis. Today's look-back exercise, this brief exercise that you have done with me, I think suggests a number of questions that might fruitfully be explored further by researchers. Legal scholars are very well positioned to help to identify strategies to mitigate the obvious risk that attempts to upgrade the legal equipment during a crisis can misfire. And of course, we need economists too to help us to articulate and measure the costs and benefits of developing relief packages that largely defer all the hard choices to later. Who will bear the cost of pandemic relief? Will they be the people that are best positioned to bear it? We need economists to help us to answer those questions and to identify feasible alternatives to the kind of strategies that we saw governments deploy in this crisis. So let me conclude with an extract from a very interesting recent issue of Economic Policy on bailouts. The policy response to the COVID crisis in advanced economies was unprecedented, both in terms of the scale and the diversity of policy instruments. Given the substantial fiscal burden it has generated, it is legitimate to ask how effective this response was. And this question turns out to be much harder to answer than casual discussions in the public debate may suggest. The reason for this is that we observe the world as it unfolds before our eyes, given the policies in place, but not what it would have been under hypothetical alternative policies. We may always speculate about how many jobs, firms, or banks we saved during the COVID crisis, but it ultimately takes a model and the ability to run counterfactual experiments with it to get a sense of the benefits associated with specific policies. In the case of the COVID crisis, the model must be sufficiently rich and versatile to capture the variety of instruments that were activated then and to evaluate how they played out, both individually and jointly. So I hope that today I have done something to convince you of the need for such research to continue and of the need for legal scholars to join in this work with a view to informing the policy response to the next crisis. Thank you, Richard.